Hello, everyone, and welcome to Uncivil Law. For today's case, we have a decision out of the United States Court of Appeals for the Sixth Circuit. This is the case of Cindy King versus Montgomery County, Tennessee. In this case, Cindy King was the owner of 15 dogs. However, they were not being kept in a good condition. In fact, they were being severely maltreated. She had a neighbor check in on them because she couldn't, because she was in jail for unrelated reasons. And when her neighbor went to check in on them, she was somewhat astounded to find out what she saw. She called for animal welfare. Pictures of this leaked on the internet, and Cindy King has essentially been blackballed by her employer and everyone else because now they know her. She's an animal abuser. Cindy King is suing Tennessee for taking photographs of her animal abuse and for releasing them to the media, and suing them because this invaded her right of privacy. Seriously, she's suing because the government violated her privacy by documenting and showing people evidence of the animal abuse. So we're going to read a decision from the Court of Appeals determining whether or not she can sue the government for violation of her privacy interests. So let's get started with this. I don't write the stories. I don't make up the law. I just tell you what it is. Oh, God. Or I'll go to hell. All right, great. Cindy King regularly kept 15 dogs at her home in Clarksville, located in Montgomery County, Tennessee. With plans to travel to Kentucky, King arranged for friends to care for the dogs during her absence. But things did not go according to plan. While in Kentucky, King ran into legal trouble and was temporarily imprisoned. One can only wonder what she was imprisoned for during her vacation to Kentucky, but let's press on. Aware that she would be away from home longer than expected, King called Carolyn Will, a friend. When Will arrived at the home, she found more than she bargained for. The house was in horrific disrepair, and the dogs were suffering in squalid conditions. She took pictures to document what she saw. Strong ammonia fumes made it hard to see and breathe, and the dog was caged without access to food or water. Believing all 5 dogs in the residences required immediate veterinary attention, Will called 911. So she had dogs in her house, caged, without food or water, with the smell of ammonia, in other words, urine, so strong it was overwhelming the room. Fantastic. Clarksville officer John Matos responded to the call. Will explained that King, who lived in the residence, was currently in custody in Kentucky, and Will had been tasked with caring for the dogs inside. Matos, the police officer, could smell strong ammonia fumes from outside the residence. The strong of urine is so strong it can be smelled outside. Great. Will graphically described what she had seen inside: appalling conditions, a lack of food or water, and dogs in various stages of ill health. I feel like I'm going to regret reading all this paragraph, but we'll do it for you guys. Will then opened the door. Through the open door, Matos could see trash and dog feces covering the floor, as well as the caged dog. Entering the home, he saw more of the same, including a dog trapped upstairs in a feces-covered room and a refrigerator infested with cockroaches. Matos took pictures of the conditions and, in turn, contacted Montgomery County Animal Control. The Animal Control officer, Jessica Cook, received the police officer's Matos's call. Animal Control Officer Cook determined the foul conditions threatened the dog's health. On that basis, Cook took the dogs into Animal Control's custody. Meanwhile, photographs of the conditions inside King's home became a topic of discussion in Clarksville. The photographs were disseminated online, with parties disputing the original source. In addition, a local newspaper published an article featuring a photograph of the feces-covered room. Shortly after the article was published, King lost her job. So photographs of this crime scene were shown to the media, and as a result, her employer looked upon this non-approvingly and fired her. Word of King's misconduct culminated in her being the subject of criminal proceedings. King was indicted on 10 counts of animal cruelty, and her dogs were retrained by Animal Control after an impound hearing. But King ultimately escaped criminal punishment. The state trial court concluded the search of King's home violated the Fourth Amendment and accordingly suppressed all the related evidence. I honestly don't know why the trial court in the criminal case suppressed the evidence here. This seems like an issue of exigency, an emergency that would allow the police to intervene in this situation. They had a witness who was visibly describing the things they saw. They could confirm these things by their own smell, and they entered the house to deal with an ongoing emergency to pets. So at least to my mind, on initial inspection, this seems like exigency. I don't know why the trial court threw it out. They did. And I'm very irritated that they did on the basis that they escaped criminal punishment. I'm not saying the trial court necessarily made a mistake. I don't have the full record of the trial court's proceedings. So it may be that this is a perfectly reasonable decision under the law. Unfortunately, I don't know why they'd made that decision. And so I just have to say that based on my impression, I'm sad that this person did not get the criminal sanction they so richly, obviously deserved. King then filed this 1983 action asserting various claims on the Fourth and 14th Amendment. Okay, let me get this fully straight. There was feces and urine and dogs in cages, and you somehow got off of your criminal charges, even though you really shouldn't have. And rather than being like, I'm the luckiest person ever, your next step was, I'm going to sue the government for infringing my rights. I hate you, King. I personally hate you. And you know what's really sad? It's like, as a lawyer, I'd probably take her case. Because, everyone deserves justice, right? So, I'd have her pay me first, though. She'd pay me in cash. But, I might take her case. Because, I've learned to be very professionally detached. I don't know if that's good or bad, but I've learned to be very professionally detached, which is good because then I don't have to take my work home with me. But it's bad because then I'm not haunted by a conscience, which I don't have anymore. So At least when I'm in my professional job. In my real life, I have conscience, but I'm very good at detaching for some reason. Probably good for my sanity. Anyways. She alleged that Matos and Cook unlawfully searched her home without a warrant. Cook unlawfully seized the dogs in her home without a warrant or due process of law. Cook and Farrell unlawfully seized 10 dogs later surrendered to animal control without a warrant or due process of law. And Cook and Farrell violated her right to privacy by circulating on social media pictures of her home. King also brought a Monell claim against Montgomery County based upon the actions of county employees, Cook and Farrell, and on the basis that the county maintained an animal impoundment procedure that violated King's due process rights. The district court agreed with defendants that none of King's constitutional rights were violated. With respect to the Fourth Amendment claims, the district court found that Matos and Cook's entry into King's home and Cook's seizure of the 5 dogs inside was supported by readily apparent exigent circumstances that gave rise to probable cause. The district court likewise rejected the idea that Matos, Cook, and Farrell violated King's Fourth Amendment right to privacy. No case, the district court concluded, stood for the proposition that the government violates the Constitution by making pictures of a crime scene public. Likewise, because none of the alleged constitutional violations occurred pursuant to policy, procedure, or custom of Montgomery County, the district court dismissed King's Monell claim and King appealed. So the district court in this civil case is finding that the police did have probable cause to enter the home. So that is contradiction to the criminal case in the separate proceeding. So the criminal case, the criminal judge found that there was not exigency and suppressed the evidence on that basis. But we're in a different case, in a civil case. And in this case, the judge is saying, well, they did have permission. Now, what's interesting about that is there's a doctrine in law that would sometimes preclude this, and that doctrine is called collateral estoppel. Basically, the proposition is when you have 2 parties in one case and something is found in that case, you have a right to appeal, but sometime that decision becomes final. And whatever is found to be final in that case is true for all cases. You can't relitigate things in other cases. It's to prevent collateral attacks, collateral estoppel. And so one of the arguments you'd bring in here If you were king was there's a collateral estoppel issue. A court of competent jurisdiction has already found something, and as a result, this court should honor it. And you could bring that under collateral estoppel, full faith and credit, res judicata. There's a couple theories there that would apply. So what happened in this case? Let's find out. Government actors are entitled to immunity from civil liability for official acts that do not violate clearly established constitutional rights. Whether immunity attaches turns on answers to two related questions. Did the government actors violate a constitutional right, and was that right clearly established at the time the alleged violation occurred? Ewan says, well, the first was under state court and the second is federal. That may be part of it, but to the best of my knowledge, it should not impact this issue because the same parties are involved, right? The criminal case was government. The criminal case was government versus king, and now it's king versus government. So it's the same parties to the same issue. So the fact this is federal may be relevant. I don't know because I've never dealt with it in this context. But my immediate assumption would be full faith and credit, res judicata, collateral estoppel. It shouldn't matter that it's state and federal. That would be my baseline assumption. But there could very well be case law that would be reading on this. So don't take what I'm saying as like gospel. But my default assumption would be it was government and king in the first case. Something was found, and now that's true for all cases. But, it could very well be that there's some federal issues here that would undermine this. As it turns out, it's going to be undermined for completely different reasons. But the state-federal thing could be part of it in a different analysis, yes. The Fourth Amendment protects individuals against unreasonable government searches and seizures. As a threshold matter, it bears noting that the state court held that search of King's home did violate the Fourth Amendment. We have previously held that preliminary hearings regarding probable cause can bar a party and those in privity from relitigating the issue in a related action brought against 1983, citing a case in the Sixth Circuit. So without reading the exact language of this Sixth Circuit case they're talking about, the issue that they're talking about is the same issue I was talking about above. This issue of res judicata, collateral estoppel, full faith and credit, something along those lines. So the Sixth Circuit has previously held that when there is two parties involved that are either the same party or in privity, that is, so close as to one reads on the other, that you can't relitigate issues that have already been litigated. Once something is decided, it's decided. You can't relitigate issues. And so they're saying in the Sixth Circuit, we have found you can't relitigate issues in this context of 1983. And that would go to those issues, res judicata, collateral estoppel, full faith and credit, or some version of that. And so they're saying that's normally the rule. Federal has overriding authority on federal constitutional matters. As to the interpretation of the Constitution, yeah, sure. As the interpretation of the Constitution, sure. So as to issues of law, but those are legal issues, right? Even not factual issues. So the federal courts don't have superior jurisdiction over facts. And you see that all the time, even like in U.S. Supreme Court cases, because you see a lot of cases that get appealed to the U.S. Supreme Court from state courts because there's a federal issue or federal constitutional issue, right? But the federal courts don't re-examine the underlying facts of whatever trial court decided it, right? So I would assume that even where it's the U.S. Supreme Court hearing the case, if in a different case involving the same parties, there was a final judgment, I would assume that it would be binding on the federal court as to the facts, not necessarily the law. So if they got the law wrong, sure. But as to the facts, I think that even the U.S. Supreme Court can't really overturn that because of all the issues I just said it's not a legal issue. Preclusion arguments, however, must be raised at the pleading stage. Because King failed to raise the issue below or in her opening brief on appeal, it is waived and will not be considered here. Accordingly, we will take up probable cause determination anew. So as it turns out, in this particular situation, all those issues are ultimately moot because King failed to raise the issue. She could have raised the issue, and as I've been pointing out, she has some colorable arguments, and apparently there's Sixth Circuit law on point that would have helped her. But she didn't raise the issue, and issues not raised are considered waived. And as a result, the court appeal here doesn't have to deal with that issue and can just reconsider it themselves from square one. Because she didn't raise it, and so apparently not an issue. She doesn't want that. She doesn't want that favorable finding for some reason in her case. So okay, we'll reconsider it and determine it for ourselves. Yay! The district court concluded that exigent circumstances justified Matos's and Cook's entries into King's home, and we agree. Where a need for immediate action by government personnel makes obtaining a search warrant impractical, those exigent circumstances can justify a warrantless entry. This exception to the warrant requirement also allows officers to ensure the safety of animals exposed to dangerous exigent circumstances. To our eye, the circumstances described to the police officer Matos would have led a reasonable officer to believe the dogs inside the home were in danger. Will told Matos that ammonia fumes made it difficult to breathe, that some of the dogs did not have food or water, and the dogs needed urgent vet attention. Even while outside, Matos could smell the ammonia fumes himself. Will's statement thus sufficiently apprised Matos of the seriousness of the situation. The same goes for Cook, the animal control officer. Cook reasonably relied on statements from both Will and Matos in entering the home. A reasonable officer in her position would have believed the dogs inside were in danger. Cook's entry, therefore, was also consistent with the Fourth Amendment. Nor did Cook run afoul of the Fourth Amendment in seizing the dogs inside the home. Exigent circumstances can also justify warrantless seizure of endangered animals. So as the court is pointing out here, exigency is a generalized exception to the Fourth Amendment, which protects both search and seizure. So the issue is exigency, and that protects both the search and seizure. The search to enter the home, and once determining that dogs need help, to seize the dogs because they needed immediate help. So the exigency warrants both in the circumstance according to the Court of Appeals in its findings. Under the circumstances, it would have been impractical for Cook to seek a warrant before removing the dogs from the residence. Doing so thus did not violate the Fourth Amendment. With the right to enter taken care of, the court is now going to consider the privacy interest of King in having her dereliction exposed by the photographs of her dirty home and her maltreated dogs being exposed for the public to see. King's privacy claim turns largely on public circulation of pictures of her home. Assuming for the purpose of argument the government officials were responsible for the circulation, King's argument still fails. Well, I suppose there is some minor justice in this world. At least she is exposed for everyone to see. She may not have been charged criminally, but everyone now knows what a horrible, horrible person she is. So that is worth something, I suppose. The Fourth Amendment's Due Process Clause encompasses a substantive right to privacy, but we read that protection with restraint. That is, to invoke substantive due process protections, a purported privacy right must implicate one of three fundamental rights protected by the clause: life, liberty, or property. The privacy rights we have recognized to this point fall into two camps: the freedom to make certain fundamental life decisions and protection against disclosure of deeply personal matters. The privacy right King asserts here pales in comparison. Dissemination of incriminating and surely embarrassing pictures may well impact one's reputation, but we've rightly refused to recognize a reputational right in privacy. Nor is the dissemination of photographs of one home protected by the Due Process Clause. At the time of the photographs were disseminated, King was the subject of a criminal investigation. Even if she did have some privacy interest in her home, that interest was far outweighed by the public's right to be aware of crimes committed in their community. We see no reason to extend that right to privacy to shield suspected criminals from unaltered photographs disseminated during a criminal investigation. So that is the end of the case of Cindy King versus Montgomery County, Tennessee. In this case, we learned that Cindy King had 15 dogs, and while away on vacation to Kentucky, she got arrested for unrelated reasons. She had a neighbor check on her dogs, and her dogs were being severely maltreated, in cages, without food or water, and with ammonia stink so high it could be seen and smelled outside the house. Her dogs were seized. Photographs of this were taken and released to the media. And Cindy King, even though she got off on the criminal charges, nevertheless had the entitlement to complain about the photographs being released because it hurt her darling reputation. However, the Court of Appeals for Sixth Circuit rightly notes that these were pictures of a crime scene, and the public has an interest in knowing about crimes that are occurring in her area. So the fact that we all know Cindy King is a horrible, horrible person now is not the state's problem, because she's been exposed to things that she was in fact doing. So I don't feel bad for Cindy King, because she was the one who was treating her dog so poorly. And some justice is done that now her name is permanently associated with being a dog abuser. And that is the end of this case.